So superannuation is a critical part of any estate plan and should be really comprehensively canvassed in any estate planning discussion you have with any client. There is no one-size-fits-all approach. And when you're advising your clients about options in dealing with their superannuation death benefits, you really need to take a broad and global approach and consider a whole range of things, including the client's family and the dynamics of that family. Blended families present particular challenges in any estate plan. The client's desire for certainty versus their appetite for flexibility, the tax consequences that flow or that will flow from the payment of superannuation death benefits, the options, so benefits and risks of nominating dependents directly versus nominating the legal personal representative, which is the executor or administrator of the estate, and the interplay between superannuation, estate and family trust. These things need to be approached together and not on an isolated basis. So we've got a lot to cover today. It's a really big topic, and here's just a recap of some of the things we'll be talking about today. So as you can see, there's a lot to cover, so I'll go sort of straight into the more technical aspects of the paper. Just a heads up, this paper focuses mainly, or this presentation focuses mainly on payment of death benefits arising from self-managed super funds. So notwithstanding that many of the principles will apply to industry and retail funds, when I talk about fund or trustee or member, I'm generally speaking about SMSFs in today's presentation. Before we dive into the paper, I'll just give a really quick summary about the payment of superannuation death benefits. Basically, the distribution of superannuation death benefits is governed by the rules of the fund and the Superannuation Industry Supervision Act. Many clients don't realise that their superannuation death benefits are not governed by the terms of their will, or that their superannuation doesn't automatically form part of their estate if they die. The relevant regulations provide that superannuation can only be paid to a dependent or the legal personal representative. I'll just call it the LPR from now on. If the death benefits are paid to a dependent directly, the benefits don't form part of the estate, they bypass the estate altogether. If the benefits are paid to the LPR, then they will be called in as part of the asset pool of the estate and then governed by the terms of the will, or if there is no will, they'll pass in accordance with the relevant intestacy provision. Now I'll use in this presentation, I'll refer to both dependents and tax dependents. There are two different definitions of a dependent. The term dependent refers to eligibility. So who is eligible to receive a death benefit under superannuation law? And the term tax dependent defines how the benefit will be taxed under tax laws. So basically, who can receive the death benefit versus how the death benefit will be taxed. The term dependent refers to the definition of a dependent for superannuation purposes and includes a spouse, whether you're married or not, a child of any age, and a person in an interdependency relationship with the deceased. And an interdependency relationship is one where there's two parties who live together, there's a close personal relationship, and one or other, each of them provides domestic support and personal care. Tax dependent refers to the definition of a dependent for tax purposes and is a person who is a spouse, including de facto, a child over the age of 18, a person in an interdependency relationship with the deceased, or any other person dependent on the deceased. So an adult child, for example, is a dependent, but is not a tax dependent necessarily, unless they fall within other criteria. So is making a binding death benefit nomination a no-brainer? Well, that depends. So when considering how to deal with the payment or distribution of a superannuation death benefit, basically the member has two options. One, they can make a binding death benefit nomination, or two, they can leave it to the discretion of the trustee of the fund at the time of their death to determine how and to whom the death benefit will be paid. A binding death benefit nomination confers a binding direction of the trustee of the fund to pay the benefits as directed by the member. So basically, it compels the trustee to pay the death benefit to any one or more of the member's dependents or to the LPR in whatever percentages or proportions are directed by the member within the binding death benefit nomination. The binding death benefit nomination needs to be valid to be enforceable, and the validity requirements will be set out in the deed and the act. So basically, it needs to be in writing, signed by the member and witnessed by two people. The deed itself might actually require some additional steps to be taken by the member to ensure its validity. So always make sure you check the deed and you comply with any requirements in the deed for a valid binding death benefit nomination. Now, if the member does not have a valid binding death benefit nomination in place at the time of death, the trustee of the fund has a discretionary power to determine who will receive the death benefit and in what proportions, and also how that death benefit will be paid, whether it's a lump sum or a pension or a combination of the two. Now, that might lead to disputes about how the superannuation is proposed to be distributed, or it may result in an outcome that the member didn't actually want or intend to incur. So some of the advantages of making a binding death benefit nomination, there are many advantages of incorporating a binding death benefit nomination as part of a broader estate planning process. The main advantage, obviously, is that it provides certainty that the death benefit will be paid in accordance with the member's wishes, because it removes the trustee's discretion altogether. This is particularly helpful if the member anticipates sort of issues or disputes after they die between family members about who gets what. So being able to lock away and sort of guarantee that someone's going to get a portion of the asset pool, being the superannuation, is really appealing to a lot of people. The binding death benefit nomination can and should be prepared as part of the member's overall estate plan, including their will, so that the assets can be dealt with as an entire asset pool, or can be used to achieve a specific goal, such as distributing a particular asset to a specific beneficiary, or directing the benefits into the estate so that they can be dealt with via the will, and perhaps flow through to a testamentary trust or a superannuation proceeds trust established by the will. You also have the opportunity to make the binding death benefit nomination with some tax implications in mind, including, streaming those death benefits to dependents who are tax dependents and who'd be eligible to receive those benefits tax-free. Now, whilst there have been some cases involving disputes involving binding death benefit nominations, a valid binding death benefit nomination is difficult to challenge. So unlike a will where we've got the family provision, family maintenance provisions in every jurisdiction, you can't challenge a binding death benefit nomination in that same way. So it limits the risk of future litigation in relation to the payment of the death benefits, as I said, unlike a will, which is open to challenge. Now, disadvantages. So whilst binding death benefit nominations appear to be very simple documents, people get them wrong. They make mistakes, and they can fail on a technicality. So with a will, if a will hasn't been validly executed to meet all the formal requirements for a will, the court actually has the power to rectify that, to fix that problem. But with the binding death benefit nomination, there's no such power. So these simple documents can fall over, because of a really basic mistakes. There's a couple of other potential limitations or disadvantages. So some things that can go wrong include that the member has nominated someone who's not actually eligible to receive the superannuation death benefit. I just actually saw this yesterday with a client who had nominated his sister to be a beneficiary of his superannuation fund. Now, that was a retail fund, not an SMSF, but this happens quite commonly where people who aren't even eligible to receive the benefit are nominated as beneficiaries. The binding death benefit nomination maybe doesn't comply with the requirements set out of the trust deed. It might not be signed or witnessed correctly. So they're just some sort of technical aspects of what can go wrong. But the bigger disadvantage is that the trustee has to comply with that nomination, whether it's still appropriate or not, and whether it's still advantageous or not. So they have no ability to exercise discretion to do something which perhaps might have been better. So, for example, the tax laws might have changed since the binding death benefit nomination was prepared, so that an allocation of benefits which might have been tax effective at the time the document was made is not tax effective at the time of death. A person who is a tax dependent at the time the document was made perhaps isn't a tax dependent at the time of death. And so if that binding death benefit nomination is valid, the trustee has no ability to vary that allocation of benefits to achieve a more tax effective outcome. The other issue which can arise is that the member's own circumstances might have changed since that document was prepared. For example, they might have made a binding death benefit nomination in favour of a spouse from whom they have subsequently separated, and they haven't updated or revoked that existing binding death benefit nomination. Again, unlike a will, divorce doesn't automatically revoke a nomination of a spouse as a beneficiary in a binding death benefit nomination. There might be a new relationship that hasn't been accounted for, birth of a child, estrangement with a child. There might be an adult child who's become disabled because of an illness or injury, but the binding death benefit nomination hasn't been updated or revoked to reflect a change in the member's circumstances. So again, this could lead to some unintended outcomes. In my own personal practice, a binding death benefit nomination is more often recommended than not. My experience is that clients seek certainty where they can when it comes to estate planning, particularly if their family or their personal circumstances are complex. Clients are aghast at the concept that their will can be challenged. They often will say, like, well, what's the point of even making a will if a court can just override it? So the fact that they can make a binding death benefit nomination, it's really essentially, difficult to challenge, and they're going to get certainty of an outcome is really appealing. But that's just my own anecdotal experience dealing with clients. Of course, some clients prefer to retain flexibility, and they want to allow the future trustee of the fund to make a decision about the distribution of the death benefit that the trustee considers is most appropriate at that particular time. But my experience is that's fewer clients take that approach than the other way around, seeking some more certainty in relation to the payment of the death benefits. So while a binding death benefit nomination isn't necessarily a no-brainer, my experience is that it's certainly very appealing to most clients. So when making the nomination, the member has to decide where the super is going to go, so he'll get it. And there's no no-brainer in terms of where it should go. Just like any good answer from a lawyer, it depends. There are benefits in nominating the LPR. so there's several reasons why the client might wish to nominate the LPR. The structure of the will is an important consideration. Generally, where clients have a simple will which just carves up or divides their estate directly to their children or their dependents, normally we have a basic, binding death benefit nomination, giving the assets directly to the children as well. If there's a more complex will, for example, one that establishes a testamentary trust or a superannuation proceeds trust, generally we'd recommend that the super comes into the estate so it can flow through to those structures and have the benefit that those structures provide. So some benefits of nominating the LPR. There's greater flexibility to deal with the death benefits as part of an estate asset via the will. The will can do more things in terms of, directions than a binding death benefit nomination can do. The member might not actually have any dependents, so it might be a single person with no spouse and no children, and they might want to provide for siblings or parents or friends or charities via their will. So they may want to gift those benefits to non-dependents. Also, grandchildren are not dependents and not eligible to receive super. So the client may want to bring the super into the estate so that they can provide for grandchildren via the will. The member might want to direct that the proceeds be paid to meet certain estate debts or liabilities. I've touched on this one already, but they might want the benefits to pass to a superannuation proceeds trust or a testamentary trust established by the will. Another instance where there might be benefit in bringing the super into the estate is that there might be a separation between the member and their former spouse. They might want their children to receive the benefit, but those children are still minors and they don't want a former spouse being paid the benefits in their capacity as a guardian of minor children. So they'd rather those benefits come into the estate and then be controlled by the executors appointed in the will. The main risk or disadvantage of nominating the LPR is that once you bring that superannuation into the estate, it is an estate asset. If the estate is subject to any dispute or family provision claim, those superannuation assets have been exposed to that claim. So it becomes part of the at-risk asset pool. Also, if there's any litigation involving the estate, there might be a really long delay before the estate is administered until that litigation is resolved. So those superannuation benefits could be tied up in the estate and not distributed to beneficiaries for a long, long time until that litigation has been resolved or determined by the court. Benefits of nominating dependents directly. It's a more direct way of providing for people. So if the will is going to just direct assets to your adult children, for example, you may as well just nominate the adult children as the beneficiaries under a binding death benefit nomination, and they receive the assets directly from the fund. It doesn't have to go to them via the estate. So it's certainly a direct way of dealing with the benefits. The main advantage is that it excludes the superannuation from the estate. So if there is any dispute or litigation involving the will or the estate, the death benefits are unaffected by the outcome of that litigation. And nor will the payment be held up pending the outcome of that dispute. If the payment is made directly by the fund to the dependent is free to use or apply those assets however they choose. So if it's a valid nomination, the member has certainty that the intended recipient will actually receive the asset. This might be particularly appealing in blended families, say where the member wishes to provide for different family members from different pools of assets. So, for example, provide for their spouse from the superannuation, provide for their children out of the estate. The risks and disadvantages of nominating a dependent is that primarily where the dependent is at risk in terms of their own personal or financial circumstances. So if you have a situation where you've got a beneficiary who is at risk in terms of relationship breakdown, insolvency, or gambling issues, whatever they inherit directly is exposed to those personal or financial risks. So in those sorts of cases, perhaps the funds would be better protected within a sort of a protective trust or testamentary trust that's established by the will, rather than directing the money to the at-risk beneficiary directly, where they might potentially lose it due to their own personal circumstances. When thinking about who should be nominated to receive a death benefit, you shouldn't overlook the tax considerations. So there are tax consequences on the payment of superannuation death benefits. Payments to tax dependents are tax-free. So due to that concessional tax treatment, there's generally a strong incentive to pay superannuation death benefits to tax dependents. So the tax consequences on the payment of death benefits depend primarily on these 4 factors: whether the recipient is a tax dependent or not. Obviously, the components of the fund. So each fund will have a tax-free component, a taxed element and an untaxed element. Untaxed element is usually a life insurance component. The taxed element is that the accumulation amount that's already gone into the fund and been taxed at 15% going in. Whether the death benefits are paid as a lump sum or an income stream, and in respect of income streams, the age of the deceased and the date of death. I won't go into the tax environment in this presentation. It's not what it's about, but just to really summarise very briefly, death benefits can be paid in the form of a lump sum or a pension. Tax dependents can receive a lump sum, an income stream, or a combination of the two, but non-tax dependents, so adult children or the estate, can only receive a lump sum. Following on from the comments about the tax considerations, when you're preparing a will for a client, you should consider, a client who also has superannuation benefits, obviously, you should consider including the following clauses in your wills. The first is an adjustment clause. This is used where the client wants to notionally treat their estate and their super as one pool of assets. And this allows the executor to offset or adjust distributions out of the estate to take into account death benefits received by a beneficiary from a superannuation fund. So if any one of the estate beneficiaries has received a share of superannuation, the adjustment clause works as an equalisation measure, which allows the executor to offset that amount against the person's share in the estate, so that the beneficiaries are treated equally. That also provides a bit of protection in a circumstance where, say, there's no valid binding death benefit nomination at the time of death, and the trustee exercises its discretion and doesn't pay the superannuation benefits, say, equally amongst children, then the executor can allow for that in the distribution of the estate and adjust the distributions to equalise that. You could also look at a streaming clause, which is relevant in circumstances where superannuation is flowing into the estate and will form part of the asset pool of the estate. Now, that streaming clause basically directs the executor not to mingle the superannuation death benefit with other estate assets and to stream the death benefits to tax dependents as possible. So the relevance of that streaming clause is basically that a lump sum paid to the LPR will be subject to the same taxation treatment as if the payment had been received by the beneficiary directly from the fund. So, for example, if a will provides for 50% of the estate to be paid to a spouse and 50% to be paid to an adult child. The 50% attributed to the spouse will be tax-free because the tax sort of follows, because the spouse is a tax dependent, and the 50% attributed to the adult child will be taxable. So life insurance and the tax implications when received within a superannuation fund. So lots of members hold life insurance within their superannuation. The life insurance is ultimately cashed out as part of the payment of the death benefit. Some of the benefits of holding life insurance within superannuation, one is that the premiums can be paid from the superannuation account, which is often taxed at a lower rate than the member's other income. The members are not required to pay the premiums personally from after-tax income, so that might be particularly appealing to younger members because they're not, who already might be struggling to meet their mortgage and other day-to-day expenses from their after-tax income. On the other hand, I'll just note that it does deplete the accumulation balance because the premiums are coming out of the superannuation, and that the premiums can be treated as a deduction by the fund, whereas policies that you hold personally are not deductible. You just pay them out of your own pocket. Now, there are tax consequences, though, on the payment of life insurance, which is attached to a death benefit. So the biggest disadvantage is that life insurance is taxed at 30% when paid to a non-tax dependent or the LPR, and where it's not being streamed to a tax dependent under the terms of the will, whereas life insurance policies held outside of a super fund, so held personally, are not subject to tax when paid out on the death of the life insured. So any life insurance component of a death benefit that's paid to a tax dependent is exempt from tax. Again, there's a strong incentive for that reason to pay a death benefit to a tax dependent where possible. I've often had the experience of dealing with adult children who are just sort of really shocked to learn that a third of the life insurance policy, or close to a third, ends up being taxed when it's cashed out as part of a superannuation death benefit. Now, deathbed withdrawals. This is a topic that's been getting a little bit of airtime in the media, and this is a situation where a member, withdraws their superannuation benefits very soon after they die. Soon before they die, not after they die. I apologise about that slip up. So in circumstances where the payment of a death benefit will result in a tax liability because the member does not have a tax dependent such as a spouse or a child under the age of 18 who'll survive them, there's a really strong a tax incentive to withdraw that benefit out as a member benefit before death, as opposed to leaving it in the fund to be paid out as a death benefit after death. So strategically, it's best to keep the superannuation within the fund during life as long as possible, and then withdraw it while you're alive, in which case it ceases being super because it's out of the superannuation environment and just becomes an asset of the estate. So a member benefit is a payment from the fund to the member during the member's lifetime. And if the member has met all the conditions of release, then the payment to that member is essentially tax-free. So you can see the incentive of pulling it out as a member benefit, where there's only, say, adult children surviving. A death benefit, on the other hand, is a payment from the fund to the LPR or the dependent after the date of the member's death. And the tax consequences depend on whether the recipient of that death benefit is a tax dependent or not. Now, sometimes it's not clear whether the payment from a superannuation fund is a member benefit or a death benefit. So For example, this could occur where the member has made the withdrawal request prior to their death, but died before the payment was received, or where the request was made prior to death, but the trustee made the payment after date of death without knowledge of the member's death. If the payment has exited the fund prior to death and is held in a personal account of the deceased at the date of death, then that clearly meets the requirements for a member benefit. That's sort of a clear one. However, in circumstances, say, where the cashing out has only been partly completed, so say there's shares and the shares have been sold down and converted to cash, but the cash is still held within the fund and hasn't been paid out at the date of death, that's unlikely to meet the requirements for a member benefit and will be treated as a death benefit. I've had a very recent matter with just these circumstances where the process had been started during the member's lifetime, the assets had been sold out, had all been converted to cash, but the member had lost capacity before they could sign the withdrawal form, and it was regarded, it hadn't exited the fund, notwithstanding the instructions were given, and that resulted in about a $220,000 tax bill. Had the member not lost capacity or had not died, this has all happened within days, it would have come out as a member benefit, and it would have been tax-free. The ATO has got their eye on these sort of deathbed withdrawals, so be obviously very careful in terms of the advice that you give. There's some very helpful guidelines published on the ATO website. There's a link in the paper which takes you directly to them, and I've just summarised them in the PowerPoint. But basically, a trustee must assess whether the payment is a member benefit or a death benefit based on these sort of following criteria. The terms of the request from the member. So did the member actually give instructions to the trustee to pay out the benefit? The terms of the trustee and other governing rules. Knowledge at the time the payment is made about whether the person is deceased or not. This is quite different in industry and retail funds compared to self-managed super funds. It'd be quite rare, I think, within a self-managed super fund environment that a trustee is unaware that the member has died. The entity that the payment is being paid to, the circumstances and timing of the payment, and whether the payment is made because of and in line with the request made by the member. It's really important to obtain both tax and legal advice in these circumstances. There's some questions that are still outstanding about whether an attorney can withdraw superannuation benefits on behalf of a member who's lost capacity as a member benefit, but that's a whole separate topic on its own that I won't cover today. So passing control. Sorry, I'll go back one step. Sorry about that. But there has just been a recent case on a deathbed withdrawal case. It's summarised within my paper, but it's certainly an interesting case, and it's only just come out within the last couple of weeks. So it's a 2024 case called Neal and Brown. Basically, in this case, superannuation benefits were withdrawn by the member prior to death. The will directed the superannuation benefits to be dealt with in a specific way. So the will was signed by the deceased 7 days before he died. On the same day he made his will, he instructed both of his superannuation funds, so OnePath and Portfolio One, to cash in his superannuation accounts. The OnePath account was paid out 1 day before he died. So that's clearly come out as a member benefit. It's ceased to be superannuation. However, the Portfolio One withdrawal request was not processed in time and remained within the fund at the date of his death. In his will, he gave certain directions about the payment of the OnePath and the Portfolio One superannuation accounts. And he basically directed that those benefits, if they're paid into the estate, were to be paid to his surviving children, to be held in trust for one of them until they reach the 25 years of age. So he wanted those benefits to end up in the hands of his children. So the issue is that with one path, it was held that the superannuation benefits had been cashed out and could no longer be described as superannuation and pension entitlements at the date of his death. Therefore, the proceeds of that one path account would not be distributed to the children in accordance with Clause 8, which specifically described superannuation and pension entitlements, but rather formed part of the residuary estate. So we had a pretty unintended consequence there. And then in relation to Portfolio 1, as the superannuation benefits had not actually been paid out at the date of the death, those superannuation benefits were determined to fall within that definition, as described in Clause 8 of the will, as superannuation and pension entitlements at the date of death, and they were captured by the terms of that clause in the will. The court in this matter described the wording in the will as clumsy, but that is what it is. So tax should not be the sole consideration in these death benefit withdrawal matters. The terms of the will, potential Part 4 risks, so taking super out of the superannuation environment and bringing it into the estate, any existing wishes of the deceased member about how they want their superannuation to be distributed, they all need to be considered when considering taking out superannuation, because during lifetime and bringing it into the estate, because you might upset something else down the track that wasn't intended to be upset by that, by pursuing bringing that out and saving some tax. Now, another thing that needs to be considered is who will take control of the member's superannuation fund on death. In every case, you should ask your client for a copy of the trust deed and read the terms carefully. So many mistakes are made because people don't read the deed. You need to look at who is currently in control of the fund and what are the mechanisms for succession of that control. Now, the superannuation rules require there to be two individual trustees or a corporate trustees. The fund can be non-complying for a short period of time after date of death, but basically it's really important that the succession of control of the trustees also appropriately structured, regardless of whether the member has a binding death benefit nomination in place or not. So leaving one person in control of the super fund where another person is intended to benefit is a common issue. So in order to ensure that the deceased members' benefits are paid in accordance with their wishes and by the persons they determine, you should review how control of the fund passes on death. So where there is a corporate trustee, so a company that's a trustee, the member will also be the director of that, and control of that corporate trustee will be determined by one or more of the following. So who the surviving directors are, who the shareholders are. Shareholders generally have a right to appoint and remove the directors. The constitution of the company, which may dictate how decisions are to be made and how the directors are removed and appointed. The trust deed, which will determine how the trustee can be removed and appointed, and whether the trustee is bound to pay the members' benefits in a particular way or to particular persons, and obviously the Corporations Act. Where there are individual trustees, the control of the trustee will be determined by one or more of the following. So who the surviving trustees are, and the deed, which will dictate how the trustees can be removed and appointed, and whether the trustee is bound to act in a particular way, and the relevant trustee in the relevant Trustee Act in the jurisdiction. Where the trustees of a superannuation fund are individuals, one of the most important controls on the succession of the trustee is the trust deed. If the member cannot be satisfied that the appropriate persons will be appointed, then they should consider ways in which the member's benefits can sort of be locked in after death. So, for example, making a binding death benefit nomination, or by hardwiring the trust deed to limit what can be done in relation to the trust after the death of a member. Now, the best way to illustrate why this is critical and where it can go wrong is with some of these cases. I'll just do a really brief summary of each of the cases. And I think they should probably all be familiar to you at this stage, but basically in Iapolo and Conti, this involved a dispute between a second husband of the deceased and children of the first marriage. It involved an SMSF where there were two members who were also the trustees, so the husband and wife. The wife died, leaving her husband as the sole trustee. She appointed her children as her LPRs in her will. She had elapsed, not BDBN, in favour of her husband, but expressed a wish in her will that her superannuation would be paid to the children equally. Now, the husband, as the continuing and surviving trustee, exercised his discretion to pay the death benefit to himself. The children claimed that as LPRs, they had a right to be appointed as co-trustees of the fund, and the court held that whilst the trust deed and the SIS Act contemplated that an LPR could be appointed in place of a deceased member, it did not compel such an appointment. Therefore, the husband remained the sole trustee and his decision to pay the death benefit to himself was not overturned. Now, in the case of Katz and Grossman, there was no BDBN. This is infamous. I expect that you all know about it. But this is another one where succession of control wasn't considered as part of the overall estate plan. This is a dispute between a sister and a brother. Their father was a sole member of a self-managed super fund. After his wife died, to ensure that he complied with the requirement that there were two trustees, he appointed his daughter as a co-trustee of the fund with him. When he died, the daughter was left as the sole surviving trustee of that fund. There was a wish that the superannuation benefits be paid equally to the son and the daughter, but the daughter exercised her discretion to pay the benefits to herself. The son, who was a co-executor of the will, brought an action against his sister on the basis that her appointment as the trustee was ineffective. The court found that the daughter's appointment as trustee was effective under the deed, and that the daughter was left with the sole discretion to determine how the father's benefits would be paid. So this case would have very easily been avoided if there was a binding death benefit nomination, but it's a really good illustrative case of where control is also really critical. Worcester and Morris is a case where there was a binding death benefit nomination in place, but there were still problems with trustee succession. So another good case to illustrate why, as part of that succession planning consideration, is determining the identity of the controller of the fund on the death of a member. So in this case of Worcester and Morris, the deceased had two adult daughters from a prior marriage. He also had a second wife. The deceased and his second wife were members and trustees of a self-managed super fund. He had made a binding death benefit nomination in favour of his two daughters from the prior marriage. The surviving second wife, on his death, appointed herself as the sole director and shareholder of the corporate trustee. She formed the view that the binding death benefit nomination made in favour of the two daughters was not binding, and as the sole director, she exercised the discretion to pay the death benefit to herself. Now, the daughters issued proceedings seeking declarations that the binding death benefit nomination was binding, and a special referee found in the daughter's favour. So In that case, even though the deceased had made a binding death benefit nomination in favour of his daughters, the control of the fund passed to the wife. Ideally, it would have been better if the control of the fund also passed to the daughters who were intended to get that benefit. Managing commercial property as part of an asset within a self-managed super fund. So it's not uncommon. Sorry, I'll just take a minute. It's not uncommon for a self-managed super fund to own a commercial property which is being used within a family business. There are fewer regulations relating to the acquisition of commercial property by a self-managed super fund as opposed to the acquisition of residential property. So, it's quite appealing to a lot of people. So many members use a self-managed super fund as a vehicle to invest in commercial property, which provides long-term capital growth. And in the interim, there's an income from leasing that property to the business. It's quite appealing that the member can essentially be the landlord and the tenant within a beneficial tax environment. There are certain rules and requirements that do need to be met. One is that there has to be the sole purpose test has to be met. The property must be for the sole purpose to provide for the member in retirement. If property is being acquired from the member or a related party, that acquisition must be at market value. And if the commercial property is being leased to a member or a related party, that lease must be at market value. The trustees must be able to demonstrate that that is the case. Now, what happens on the death of that member where we've got a commercial property within a self-managed super fund? The regulations say that the member's benefits have to be cashed out as soon as practicable after death. Now, that can be complicated if there's a property, but that can be paid out as a lump sum in the form of an in specie distribution of property, but the transfer would have some tax consequences as a CGT event occurs on the transfer of property. But from an estate planning perspective, the member has to consider that if a beneficiary operates the business, whether the beneficiary also requires that asset or control of the asset as a critical part of that business or to continue to viably operate that business. So, the business might be operated by one child who was leasing that commercial property from the self-managed super fund. We need to look at a broader estate plan to say, well, would it make sense if a different child inherits that commercial property? How is that relationship going to work and how does that affect the ongoing viability of the business? Often there will be other related entities involved in the business, family trusts, companies. Again, you need to look at this broadly and globally. The succession of the business entities on death, the control of the fund, the transfer of commercial property in specie as a death benefit, that all must be aligned with the intentions of the parties and considered together to achieve the right outcome. One of the risks is that if an in specie transfer of property is not viable, the trustee might be forced to sell that commercial property in order to pay a death benefit in cash. The loss of control of that business premises could really have significant consequences for the business. You might have read in the newspaper recently about this new Division 296 tax. That's not its formal name, but that's what it's become colloquially known as. It's certainly getting a lot of attention in the legal community and generally in the community. In November 2023, Treasury released some draft legislation that is being debated in the Senate as we speak. The Coalition has already stated that they'll repeal this Division 296 tax if they're elected at the next federal election. But basically, it proposes to impose an additional 15% tax on total superannuation balances over $3 million. This is a standalone tax paid annually by the member in addition to any other taxes. If passed, those laws will come into effect on the 1st of July 2025, and the regime will apply to any member who has a $3 million total superannuation balance at the end of the financial year. The tax is only applied on the earnings, which is basically the difference between the member's opening balance and closing balances for the year. It's one of the controversial aspects of this tax is that it's not proposed to be index. And earnings also includes unrealised gains. So there's some sort of controversial aspects to that tax. There are 3 proposed exemptions to the regime, which is relevant from an estate planning perspective. And these include child pensions, which are funded from death benefits, structured settlement payments, and a member's balance in the year that the member dies. From an estate planning perspective, the potential outcomes are as follows. So if the death benefits are paid out as a lump sum, there's no Division 296 issue because the assets exit out of the superannuation environment. However, if we're talking about a fund with spouses, where the death benefits are paid as a pension, there are 3 possible scenarios. So the first is if the death benefit plus the survivor's own balance is under $3 million, then there's no issue. The second scenario is if the balances are already over the $3 million cap, then in the following year they will be taxed on the total balance pursuant to Division 296. But say if the spouse's balance are under $3 million, they've got $2 million each, then on the death of the first spouse, the survivor will be pushed over that $3 million threshold. In the year of death, there will be no issues because that exemption that I mentioned earlier applies, but in following years, that survivor does have a Division 296 issue. So clients will require some modelling with advisors to determine which option is best and how this Division 296 tax will affect them. I'll just go through a really quick case study. This is also a very recent case that's just come out, but it's one which talks about capacity to make binding death benefit nominations and deathbed withdrawals. So on this one, we've got a binding death benefit nomination made on the same day as death. That binding death benefit nomination directed the benefit of about $4.7 million to be paid to a de facto spouse. The trustee refused to accept the binding death benefit nomination on the basis of incapacity and non-compliance with the Act and the regulations. Those 2 later arguments were abandoned, but there was a dispute about capacity. There was evidence tendered in the form of file notes, emails, telephone calls, conversations with advisors and medical practitioners. The court confirmed that there are capacity requirements to make a binding death benefit nomination, but it's not the same test as making a will. It's a more basic document and the test is more basic. And the court ultimately was satisfied that the deceased understood the nature and effect of the document. That's sort of the test for the capacity, which is not the same as the Banks and Goodfellow test for making a will. That's interesting in itself because that, the superannuation was $5 million here nearly. With a basic capacity test, you might have an estate with a much smaller balance and a more rigorous test around capacity. But notwithstanding, in this case, the court was satisfied that the deceased did understand the nature and effect of the document, and there was evidence that he understood the general nature, and in his words, he was able to say that he wanted to avoid his de facto Lindy being taxed out of her brains, which went to establishing that he understood that the payment of the death benefits to his spouse Lindy would be tax-free, and the court directed the trustee to pay the benefits to his de facto spouse Lindy in accordance with the binding death benefit nomination. So that brings the formal presentation to an end. I've got a couple of questions. I've got a few minutes to answer them. So the first question says, to send super via a BDBN to a super proceeds trust or testamentary trust, does the BDBN need to leave it to the LPR, or can a BDBN create that superannuation proceeds trust or testamentary trust? The answer is that it has to nominate the estate. It's the will. The will is the instrument that creates either the superannuation proceeds trust or the testamentary trust. So the BDBN needs to direct the super proceeds to the LPR, and then the will establishes those structures within its own terms. You can't create that itself within the BDBN. The second question is that can super proceeds be passed on to a superannuation proceeds trust if it has been nominated directly to a spouse? I believe the answer to that is no, that again, the superannuation proceeds trust is established by the terms of the will, and the benefits need to first be paid into the estate to the LPR and then flow through to that structure via the terms of the will. So thank you. Thanks everyone for joining.